We remain as consultants to him and as his brothers and braves in council.
Okay, based on today's proceedings, what did you observe and what is the way forward?
Well, my observation is that let's keep in mind that 14th October this year made it 10 years that this case has been pending. That the matter has become too complicated for the judiciary to handle underscores our core point, that this matter is more political than legal. That this is a matter for the executive branch to settle with a political sleight of hand. It's not a matter to be offered to the limited wiggle room of a court of law, of the judiciary. There is a lot of wide bat, a lot of wide space left for politicians or political leaders of this country to resolve political issues that border on agitation. Why this one has become intractable is very, very, very disappointing. There's a thesis that has become intractable because Nnamdi Kanu is an Igbo man. That thesis is becoming more and more valid by the day. So what is playing out in court now is nothing but the best evidence that this matter has gone beyond the province of judiciary and should be taken back, by the executive branch that started it anyway. There is no trial without prosecution. So it's the executive branch, the president, that triggered this through the office of the Attorney General. So the president can direct the Attorney General to take the case back to the table to see whether it should be resolved politically. But to try to resolve this case before the courts is becoming more and more impossible every day.
Is this a call for political intervention on this case?
Well, of course, everybody is calling for that. It's not throwing in the towel. What is wrong with calling with reconciliation when the courts of the land actually recognize it as well? Check out Section 17 of Federal High Court Act. It called on judges to seek reconciliation between litigants before them, including criminal cases. Section 174 of the Constitution empower the Attorney General of the Federation to discontinue criminal prosecutions. So why should anybody say this matter should be resolved in courts when we have an alternative route of resolving it politically that appears to be easier and that would appear to be pleasing to everybody?
Okay, let's talk about the proceedings today.
The procedure today?
The proceedings today.
Okay.
What next?
I will yield to one of my colleagues to discuss that.
It's good for us to put the record straight. Mazen Nnamdi is not saying that he will not enter defense. Mazen Nnamdi said, under what law are you charging me? Going by the Constitution, there is no charge against him. That tell me the law, that the court should tell him the law upon which he's been tried. Now, my Lord is on his own saying that whatever thing that you have to say should be ruled at the final written address, and it should be upon a conviction to know whether you are supposed to be convicted or not. And Mazen Nnamdi said no. There are thresholds, there are hurdles upon which you need to cross for you to reach at that particular issue. And one fundamental issue there is that my Lord said, we are talking about issue of extraordinary rendition, the way you have been brought back from Kenya to Nigeria. And he wants somebody to come and give evidence on that. There is nothing before him. And if you watch the motion Mazen Nnamdi filed, Mazen Nnamdi said, Federal High Court has given a judgment in respect of that, and also awarded 500 million naira against federal government in his favor. That judgment is in the court file. Court of Appeal, in their judgment, also gave a ruling on that and made comment about that. CTC of that judgment is in the court file. Supreme Court, in their judgment, also took judicial notice of that and condemned that attitude. They are all in court file. There was a motion challenging the decision of the court where these issues are being raised, and Mazen Nnamdi made reference of the motion in the court file. Yes. And under the Evidence Act, Mazen Nnamdi is saying that under the law, court is under obligation to take judicial notice of every document in your file. Yes. So asking him now to go and enter into a defense and start giving evidence on that is a waste of time. Yes. That court is on its own supposed to take Suomoto raise this issue.
Yeah.
Court is expected to raise this issue. Now there is a charge before me. Please, under what law? Address me on this issue before I go into trial. And Mazen Nnamdi Kanu filed a motion, and I think that motion, Mazen Nnamdi Kanu said that motion should be heard, and all this issue I raised should be trashed for me to go into trial. So, and into defense. So my law, Mazen Kanu maintain his position on that. So my lord said that he has joined to tomorrow for him to enter defense. Just like we said, you know, we are no longer into the matter, but we are still he's still consulting us. I am saying so. On handling his matter in court, he felt that he's competent to do that. So whatever advice he needs from us as his lawyer, we should also offer the legal advice, just to get the record straight, so that people will not say that Mazen Nnamdi Kanu refused to enter defense. No, there is no such issue. Mazen Nnamdi Kanu said, address me on this issue.
Okay.
That is the position.
The honorable member here will...
My name is Right Honorable Obi Agocha. I represent the great people of Ikuano, Umuahia North and Umuahia South Federal Constituency of Abia State. I represent Mazi Nnamdi Kanu. From what I saw today in court, there seems to be a systemic effort being put in place to steamroll and railroad Mazi Nnamdi Kanu into putting up a defense and leading to conviction. There are procedural issues that must be heard before the matter can go forward. And I think that is the motion that must be heard, hopefully by tomorrow. Nnamdi Kanu still remains a prisoner of conscience. He's been detained unlawfully. And we are also using this medium to continually call on Mr. President to invoke Section 174 of the Constitution of the Federal Republic of Nigeria as amended for the Attorney General to enter a nolle prosecute, at least before the determination of the court. We are very optimistic that Mr. President, that we know is a listening and attentive president, and that he will do the right thing in the shortest possible time. Thank you.
My colleague here would like to...
Okay, thank you very much. Yeah, thank you very much. Well, as an ordinary citizen, as I'm not speaking now as a lawyer, as an ordinary citizen, if I am brought before a court of law, I should know the law that I have contravened.
Yes.
You cannot ask me to enter a defense for a law that does not exist, and particularly the law that the Supreme Court itself has declared non-existent. To what will I be defending? We're in a country where our laws are written. This is not England, where you have an unwritten constitution or unwritten law. We have a country where all our laws are in black and white. This is a lawmaker here. They made the law we're talking about. And if you ask him, he will tell you that there is nowhere they made chapter 45 of the criminal code. They didn't make it. The Honorable, did you make that law? It is not in existence. So who made that law? Who made that law? Was that law made by the Attorney General's office? And the Attorney General does not have the powers to make laws. So I am saying, as an ordinary citizen, that Mazi Nnamdi Kanu is completely right and within Section 36 of the Constitution, which borders on his fundamental right to fair hearing, to be charged in a court with a law that is in existence, not with a law that is not existing. Wonderful. Thank you.
Thank you.
Kanu, for the purpose of this trial, is representing himself in this matter. So, and on this particular issue, we are now acting as his consultants. I'm not the only one. He has many consultants, both foreign and local, whom he consults on this particular issue, not representing him here. Now, if you recall, Mazi Nnamdi Kanu has, to tell you that he's ready for his defense, has listed the witnesses he intends to call in this particular matter. So, in the course of consulting, he discovered that the law upon which he's been charged and tried does not exist. So ordinarily, the court is expected to raise this issue and ask the parties to address him on this issue, whether the law does exist. So now Mazi Nnamdi Kanu has raised the issue and said that I cannot enter defense because in a criminal jurisprudence, we have a procedure. The procedure is that for you to even assume jurisdiction, there must be a law. For the law to even exist, for you to rely on that law, the law must be an existing law. And Mazi Nnamdi Kanu now on his own file a motion on this particular issue, telling my lord that the law upon which I'm being tried does not exist, in line with section 36 sub 12 of the Constitution. But my lord on his own, just like what we said, my lord on his own said that section is talking about conviction. And Nnamdi said, no, you can't be talking about conviction without trial. The trial will lead to conviction. So for you to even talk about conviction, you must first of all address all those issues that will lead to conviction. So that is why we are here. It's not as if that he don't want to enter defense, but he's saying, tell me the law upon which I'm being charged and tried.
But why are we here at this stage, knowing that at a point he once pleaded not guilty, and then the witnesses from the prosecution were examined and cross-examined?
If you say that you are not taking plea, then how will you tell the judge to discharge and acquit you for no trial? Because you first of all plead guilty. Are you saying you first of all plead guilty for court to have jurisdiction for you to even make an application? If you do not plead guilty, there is nothing before the court. So that was the issue. And he's now saying that if the law, the charges upon which I pleaded guilty, does not exist. We are talking about law.
Yeah, what about the trial? There was a trial.
The defense opening their case.
The prosecution
you can raise it. The law says that you can raise all this issue at any stage.
Okay.
Before judgment. You can raise it at any stage. Either before prosecution open his case, upon prosecution closing his case, or at any stage. So that's the stage Nnamdi is. So on our own, so we believe that the court will first of all hear this particular motion. I hear them saying, but just like the court said, the court has every right to take decision one way or the other. Then Nnamdi still have opportunity of going on appeal.
Thank you very much.
It's my pleasure.
I mean, we are going through a phase in our life, in our career. The most important
I hope we're still on track. Absolutely. Please. Absolutely. Yes. Absolutely. Please. Please.
I've tried my best. I've got CLO. You see, when you come to don't say anything. You see, if you just wait and observe, relatively fast, those people are taking it. I wanted it. How are you? Good to see you. Kanu, hello,
Now, as I've said earlier, there is a discussion of the court taking into consideration all the conditions laid down in Muhammad Abacha v. State. At this stage, I am of the opinion that to make or take a stand on the bail application without first hearing and determine the issue that is glaring in the face, which is the absence of the defendant from the court since 25th of April 2017 until he was produced on the 29th of June, my lord, which was exactly what the Supreme Court did. They said that he did not jump bail. These criminals came to my house to kill me. That's what the Supreme Court said. This is in your own court, my lord. So I cannot understand, my lord, why my trial will be conducted contrary to the Constitution of Nigeria that said I must have free and unfettered access to my counsel. Is here. Okay. He did something in my case, I refused him. He was something official. I asked him to do himself. Why did the chief judge insist I must write? He left my case.
Okay, listen. If Anybody is not happy with this. So you need to go on.
No, I cannot. Because I have a godmother. I have a godmother, you have released yourself. I have a godmother. Anybody who disagrees with this order of God, go to appeal court. That's what you tell me all the time. You are from this official. You cannot preside over this case number again. Not in this life. You cannot. Not now, not tomorrow, not ever. A godmother here cannot force this court to preside on my case. You cannot. Not today, not till forever. You are recused and you stand recused. Tell the chief judge, Nnamdi said, go on appeal. I recused him from my case. The state recused Justice Adema from my case. I did not insist Adema must hear my case. I never insisted. So why must you insist to hear my case? I don't want you in my case. I don't need you in my case. You are biased. You are biased if you are not in my case. I don't want you to do the right thing. A chairman of the board of medical prosecution is impropriety. Nowhere in the world such nonsense law. You cannot be hobnobbing with lawyers, hobnobbing with justices, and you're proceeding a case. It's shameful. Absolutely shameful. Shameful. This is not a court of law. This is a shrine to injustice. And I will not subject myself to it. You stand recused and you must leave my case. You cannot buy me.
Ant Dog. Gift card trading app. High rates, fast and safe. Multiple cards.
There is an order of recusal, and he's a senior advocate for goodness sake. There's an order of recusal. Is that not the rule of law? The law says if you disagree with this, you go and appeal. You are a grown-up man. Because of 300 million, you're behaving like a child. Go and appeal. Because of money. Because of money they're paying you from ATM's office, you are here standing and smoking evil. Because of money. A grown-up man like you. You say you have to want to behave like a man of honor. The rule of law says you go and appeal. His lordship Peter, you will not try my case. Not on this planet Earth, I'm telling you that now. So stop wasting your time.
So that as I said, the issue of the past that the defendant has indicated that he will not make a formal application. I advise that the lordship was a 70-day for hearing.
You are not well. You are not well. I'm telling you, this is God Almighty not well. This is an order of God. An order of God says, Justice Binta Nyako is recused to. An order of God. Order she made as an order. The same Chief Justice writing the stupid memo he's writing. I recused him. He was Fontus official. He sat on appeal. I took him to NJC. I recused him. Why did he not say I must sit on your case? Why in the case of his lordship is he insisting? He wants to embarrass her. He wants to embarrass your lordship by asking her to come and sit on this case. Is that what you're saying?
Please,
That's an order. Give it to him. He doesn't have it. Give him an order of court. It's an order of court. Give it to him. He doesn't have it. An order. Give it. He doesn't have it. It's an order of court.
I take your permission.
It's an order of court.
I take your permission to address you. But let me tell the defendants that in everything life, there's need for wisdom. And wisdom is very important in this matter.
And tell him lies.
It is not right for you to be insulting the teacher and insulting.
If you insult yourself, I will insult you. If you have no respect for yourself, I will insult you. Because people are telling the law, when it comes to Nnamdi Kanu, you turn the law upside down. The law says one thing. If the law says this paper is white, when I go to court, they say it's black. When I say it's black, they say it's white. Is that law? I'm asking you, a senior advocate of Nigeria, is that law? Is the memo from Chief Judge, is memo from Chief Judge sufficient to set aside a court order? The answer is no. Why do you want to change the law in my own case? His lordship, Justice Binta Nyako, stand recused in my case. Cannot try me. Why don't you get it?
Strong factors. You talk about thorough investigation. You talk about diligent prosecution before a committed judiciary. And how are these playing out now? Let me start from the aspect that has been of concern to quite a number of stakeholders, that, the Court of Appeal came to a conclusion that release him dropped the charges against him. And the federal government proceeded to the Supreme Court. And since 1963, when we became a republic,